BYU Law School presents The Future of Antitrust. The competition is Collateral, How U.S. Trade Policy is Reshaping the Global Economy Conference, was held in Washington, D.C. on September 26, 2025. This session is titled The U.S. Trade Policy and Antitrust Nexus.
All right, we're going to go ahead and reconvene to get started here on our second panel. They're going to be cleaning up lunch out in the foyer, but the desserts and other snacks and things are still going to be available over here in the room. So this second panel, I'm going to turn it over to Brooke Smith. So Brooke is a visiting assistant professor at Arizona State University's Law School. She and I are good friends. We both overlapped in Chicago for a period of time together, and I'm grateful that Brooke is here to moderate this second panel. She is very much an antitrust law expert, which is something that I cannot say. And so I'm going to turn it over to you, Brooke, to get us started on this next panel.
Thanks, Craig. Awesome. So we've heard so much great trade stuff from our trade experts, but we are here at an antitrust conference. So it's time to dig in to some of the weeds of the antitrust issues. And we've had a few issues alluded to really helpfully in the prior panels, but we've got a lineup of antitrust experts for you here to talk a little bit more about the intersection of these two policy regimes about antitrust and trade. And I'm thinking next year we should also invite our tax colleagues and our labor colleagues, and this has been really beneficial and helpful to hear perspectives from experts in different fields. So I'll go ahead and let our panelists introduce themselves, and then we'll start with same format, some pre-prepared questions, and then questions from the audience. John, do you want to start?
Yeah, thanks. Thanks, Brooke. My name is John Yoon. I'm an economist, but I'm at George Mason Scalia Law School.
My name's Okeoghene. I am a lawyer at the University of Cambridge in the UK, teaching competition, antitrust, EU law, regulation.
Hi, I'm Robin Crauthers. I'm an antitrust partner at McCarter in English. Before I went into private practice, I was at the Department of Justice Antitrust Division.
Hi everyone, I'm Megan Gerking. I'm a partner at the law firm Morrison Foerster, where I practice antitrust. And prior to being in private practice, I was at the DOJ in the antitrust division.
Awesome, thank you guys. So we've alluded to some of the overlap between antitrust and trade, but we have some law students, some non-antitrust, some non-trade people here. So I want to start us off with, at a high level, what's the relationship between these two policy regimes? Should they be viewed as independent, complementary, contradicting policy domains? And we'll start with John to give us the conceptual overview, and then anyone else who wants to chime in, go ahead.
Thanks, Brooke. So, I learned a lot from the first panel, and so a lot of what they said I absorb and I agree with. So, but in terms of my position, I think they should be administered independently in the sense that we need predictability in terms of how various areas of the law will be operated, or policies, whether it's trade or whether it's antitrust, especially antitrust. And so I'm a strong advocate of that. Of course, predictability isn't the only thing that we value in law. We could be predictably wrong, so that's not enough. But I do think that's a pretty strong value, especially for business conduct. That being said, we have to recognize the reality, which the first panel shared quite well, that these will intersect, and there are times when we have to be mindful of the intersection with trade policy. Just to give an analogy, the way I view it is sort of how antitrust and IP work together. IP, of course, we all know what it does in patent and copyrights. It confers potentially, but it doesn't guarantee some degree of licit market power, and you can exploit that market power however you want. That's baked into the Constitution, certainly with patents and copyrights. But what is antitrust concerned with? It's concerned with illicit use of market power. And what does that mean? That's why we have attorneys and economists working together. But at the end of the day, we recognize conceptually that we want to stop that illicit market power. And so there's often intentions, like with FRAND and standard setting organizations, where you're trying to license that IP, but that could run into antitrust issues. And I see trade in a similar vein. There's going to be times where there's tensions, and times when you take whatever trade gives you, and you apply the antitrust laws. So that's kind of my broad perspective. But moving specifically to trade and how it affects antitrust, and I know we'll unpack this, so I won't go into depth of each of these, but I hope we'll discuss it further. As the ambassador laid out, what is it that tariffs do? They distort, and I use distort in a purely positive sense, not saying normative, maybe we want to distort it, but it distorts sort of the market mechanisms between domestic and foreign suppliers. It raises barriers to entry. It certainly favors domestic suppliers, relatively speaking. But I think we should think dynamically, and I think this is an important key implication. What will happen with tariffs that are permanent and long-going? I think you're going to see greater vertical integration. And vertical integration, why is that beneficial? It could avoid the tariffs, and it could also, unfortunately, I think in this case, it can ossify incumbency and market power. How so? Who is best able to weather sort of changes in how you structure your firm in order to minimize the impact of tariffs? It's going to be the incumbents, and they may already be largely integrated relative to smaller competitors. So I think these are the unintended consequences that you may see with tariffs that implicate market power potentially, but you have to take that as given and you work from there. Of course, there's other things we should be mindful of, and I hope we'll talk about them, and I'll close with trade associations. I think trade associations are really an area, Christina sort of mentioned, not directly trade associations per se, but sort of announcements and sort of calls. I think that danger of collusion when you put pressure on markets and margins and pressure on prices, there is a danger of coordination on that. And I think that's something that agencies should dial up in terms of their scrutiny with the implications. But that's just the start, and I'll stop there.
Okay, so I'm going to speak with no nuance, but there's always some nuance to everything I say. But I'm going to ignore the nuance. Broadly, the rules are complementary in that they're both sets of rules, and I'm using rules rather than policy for a moment. But both sets of rules are about efficiency, and so although there's been the death of the neoliberal order, we at least must stop thinking about the rules as being about efficiency that way. So they're complementary in that sense, but they're different in that the addressee of the rules are different. So the trade rules are addressed to states. You're looking at how states are going to behave. States and government legislatures are going to behave, whereas your antitrust rules are addressed to corporations, individuals. So you've got some rules addressed to states, some rules addressed to corporations and individuals, and so you broadly define them, so there were trade rules and antitrust rules, and that there would be some public law, trade rules, and there'd be some private law, the antitrust rules. Conceptually, I would start with trade rules, these rules that I would address to governments and states, and I'm then seeking to remove barriers to trade, and they are tariffs, lots spoken about, but also non-tariff barriers to trade, probably less spoken about, but more prevalent and difficult to identify. A good example is actually to look at the EU treaty and the way it defines its trade rules. So an example within the EU treaty is Article 34. It just says quantitative restrictions and measures of equivalent effect on trade between member states shall be prohibited. Okay? So it's just trade rules. It's got quantitative restrictions, a quota, any measure equivalent to a quota shall be restricted. Okay? And that's a rule addressed to states. So the states are now removing the barriers to trade between the other states. The requirements that end up limiting trade are things like labelling. What label you put on your good can affect the good moving from one territory to another, particularly within the European Union, where there might be a language requirement of the label. So if it needed to be labelled in the local language, this would prevent the good from moving from one territory to another. Okay, so you can have rules like this. If you're thinking more internationally, it ends up being things like food standards. What ingredients might be included in a food, what ingredients might be included in a food to be called the name of the food, how much chocolate must be in chocolate for it to be called chocolate. So you get lots of these things. This is what ends up being the focus of discussion. You try to remove these barriers to trade. Then you need to add some antitrust rules addressed to private parties. The danger being that, having removed the rules that the states would use to protect the domestic producer, private parties themselves would recreate the barriers that have been removed. And so you need a set of rules that would address this idea. Probably a good example of this would be work done in environmental standards. So here what could happen would be that you would say you'd have no rules on environmental standards, but private parties might have a collective boycott saying we are only going to sell goods made to this particular standard. So even though the trade rules say the market is open, the way that the private parties have contracted, the market is not open because we're not going to accept anybody that has not made goods or services according to our standards. So you've got a complementary set of rules, some applicable to the states opening up the market, but you do need some antitrust rules applicable to private parties in order for that market to be open. So the two sets of rules will work in the same way. Policy, I think, as the ambassador mentioned, is more open. You can use your policy as a negotiating tool for all manner of reasons. So in coming up with my trade policy, I've just got all manner of reasons why I will or will not open up my market. But as I open up my market, that is going to affect how much competition my domestic producers face. I'll leave it there, but we can come back and discuss.
All right, well, I have only a couple of small points to add. So, Oke talked about the contrast between who the trade policies are directed at, which is the states and other countries, and the competition policies, which are aimed at private actors, companies, firms. The other way to think about this is what is the goal of a policy? So the trade policy is aiming at protecting producers. If it's a protectionist policy, they want to protect the domestic producers, whereas an anti-competition or a competition policy is aimed at protecting the consumer welfare. And those are two divergent purposes, yet it's correct to say that trade policy has a very similar effect to competition policy in that free trade will lower barriers to entry, which is a pro-competitive part that is considered as part of antitrust. John mentioned that the implementation of trade policy can sometimes incentivize cartels, and that the agency should be watching for cartel activity. There is a flip side to that, in that the foreign countries, the non-domestic protected entities, might be incentivized to cheat any cartel agreement in order to win a market that they are otherwise closed from because of high tariffs. So again, there's sort of some give and take in that area. And then I just wanted to briefly talk about an example of where we've seen competition policy act like a trade policy. So a few years ago, Qualcomm tried to buy Broadcom. The U.S. competition authorities were adamantly against letting this merger go through. And it is believed that this was because they wanted to protect the American telecommunication market from Broadcom, which was a Singapore company. There's a fair amount of evidence on the record that this was the reason why the U.S. was so pro enforcement of this merger, and that is a way in which you can pull a competition lever that the trade lever wasn't particularly efficient at, if your goal is to protect your domestic market.
Yeah, just to add on and maybe pull a few of these points together that are all very interesting. I think we've been talking about how trade policy and antitrust policy have been traditionally kind of working in parallel. The idea being that free, open markets, from an antitrust perspective, are most beneficial to competition. They're going to antitrust is going to shut out or shutting out rivals of markets, protect free enterprise, just as much whether the barrier is created by the state or a monopoly. But recently, under America First policy, trade policy, we're seeing that trade policy and antitrust enforcement could be potentially at odds, because tariffs can have a significant impact on private companies. Tariffs can create a lot of uncertainty. They can favor certain firms within a market, like domestic producers, and limit the ability for foreign companies to compete, especially those that rely on foreign inputs. And this kind of uncertain environment with tariffs, with the threat of tariffs, can also, as John mentioned, kind of create incentives or create opportunities for firms to engage in or participate in conduct that might be scrutinized under the antitrust laws. For example, price fixing or price signaling, which is subject to a lot of scrutiny, exclusionary type conduct by firms that might gain market power in the US, and other types of conduct that I'm sure that we'll all discuss throughout the panel. So that trade policy just being in tension with antitrust law, I think actually increases the importance of antitrust enforcement to ensure that consumers have widely available goods at competitive prices, and they're not being taken advantage of by firms in this kind of uncertain environment. But it's not surprising then that the current DOJ Antitrust Division Assistant Attorney General, Gail Slater, she has been asked kind of repeatedly, as she has said in her own words, about how she squares this America First trade policy with antitrust enforcement. And she really kind of walls off the two by focusing on the fact that antitrust enforcement, it's a type of law enforcement. Antitrust, as Oke mentioned, it's meant to affect the actions by private companies and make sure that private companies are not enacting their own types of barriers or increasing prices, decreasing output, decreasing innovation in a way that harms consumers. And so she has said, well, she has an America First antitrust policy. And she's kind of repeatedly said this in a few different public speeches, that she's focused on enforcing the antitrust laws, the Sherman Act, Clayton Act, and other federal antitrust laws. So I think it's also clear that this America First antitrust enforcement policy will continue to guide the DOJ and the FTC in this administration in terms of priorities. For example, I guess we'll talk about this in a bit, but we'll see them focus on specific industries, specific types of conduct that would have the most impact on everyday consumers and also labor.
Yeah.
Awesome, thank you all. There's so much to unpack there. I have like 15 follow-up questions, but I'm going to rein it in and move to our next planned question. We'll start with our academic panelists. And you've touched on this a little bit, but maybe you can get a little more specific and explain the mechanisms for those who aren't as familiar with how it would work. What risks are implicated by the current trade policy, by the high tariffs specifically that we're seeing right now? We talked a little bit about potential collusion, about ingraining incumbents. Can you spell that out a little bit more, and any other risks you would identify?
Yeah, so what I'm really interested in is a lot of the positive analysis and holding aside the normative for the moment of whether this is good or bad, because trade policy can be used in a variety of ways and levers: national security, fair trade, it uses a tool there, domestic and foreign policy. All those are normative sort of goals, and so holding that aside, what's the implication on markets? And I mentioned the vertical integration. Just to give an example, I read that, Noble Wheels, which is a Canadian bicycle company, announced because of the tariffs, they're going to open a facility in Washington State that's both production and distribution for their wheels. And so that's, to me, that perfect example of the incentives of changing the structure of how firms are. We learned this from Ronald Coase, his Nature of the Firm article, which guided this precise point of how firms organize themselves is based off of incentives. And so this changes incentives. Another is Apple. What did they announce? What was it, $500 billion over the next 4 years of investment in domestic production and output, which again is restructuring how Apple operates in order to minimize its impact from the tariffs. And I don't know if Noble Wheels is their version of Apple and Google, but I do tend to think that this favors those who are better able financially and just through market structure to weather these storms. And so that's a concern to the extent that we think market power is something that we are opposed to. And so I think we should be mindful of that. A second point is, what are ways in which firms, holding aside the collusion and sort of the temptation to collude on surcharges and have an industry standard, holding that aside, what are ways that you can gain back your margin, gain back your share? One of which is input costs, and how do you get an advantage? One is integration, but maybe there's a greater danger for exclusive agreements where you are sort of giving up your ability and freedom for that trade-off of really lower input costs. Again, that could help incumbent input suppliers really exercise greater control. So in a lot of ways, the market power tension to me is unavoidable with tariffs in terms of if it's durable and it's predictable and it's long lasting. I do think these effects are going to be there. But just like IP can confer, doesn't guarantee market power. Antitrust then takes that level of market power and deals with it, because as we all know, antitrust isn't necessarily against monopoly per se. It's the extension illicitly of market power, and we spend a lot of time in ink and law school classes learning what illicit versus illicit market power extensions are. But assuming we have at least some boundaries of that, it's going to do that. It's going to confer that market power. What do we do from there? Let me just close by saying I found it really interesting that the ambassador mentioned the neoliberal, and I'm not 100% sure the parameters of that term, but I thought I heard Friedman, Chicago, Reagan, and all those thrown in, and tying that with the consumer welfare standards. So let me just give a basic defense of the consumer welfare standard, at least, and maybe this is going to be very unpopular, but I do think there's a sense that, like markets, completely free markets, the consumer welfare standard is like a race to the bottom. It's looking just a maniacal focus on price and efficiency at the cost of labor and all other sort of values that we tend to have. And maybe that's some people's view of sort of a market-based antitrust enforcement. That's not my perspective, and I don't think that's what the consumer welfare is doing, because at my time at the agency, it wasn't about price only. It involved quality, it involved quantity, it involved incentives on innovation. Market-based economies grow not because of low prices. They grow because of innovation. This is a consistent economic standard. Robert Solow won a Nobel Prize showing market-based systems work well because they do the best in innovation. And so to me, that's the golden goose. How do we incentivize through antitrust, through market-based systems? How do we keep that innovation flowing while obviously reining in market power? I think that tension isn't easy, and so it's not a pure defense of the purity of the consumer welfare standard or market-based system, but it's just to clarify and to round out what the objectives are that I saw when I was at the agency. I think it's a little more robust than just focused on low prices, and labor practices are key. There's labor laws. If someone violates it to gain efficiency, that's not legitimate efficiency. That's a violation of basic human sort of dignity and rights. And so I don't think the market system incorporates and says that's good. It takes labor conditions as sort of given and goes from there. So that's at least sort of my view of a market-based system as it applies to the consumer welfare standard.
Before we go to, okay, I'm going to throw this out to the trade people to mull on. Innovation is a word used often in the antitrust context, that we want to spur innovation, we want conditions to be ripe for innovation. I'd be interested to know the trade perspective on that. Is that a consideration in trade policy? Is that something we think about in the context of barriers? Think about it. Okay. Okay.
So just thinking about about the rest of it. So
yeah, going back to risks.
yeah, there were tariffs which somebody has got to pay, and so although somebody's got to pay, it's not determined who has to pay. And so the initial risk would be whether or not there'd be some collusion as to the passing on to ensure that like a particular set of consumers would pay. So there'd be this standard antitrust concern addressed to collusion. But moving back a stage, and what Robin has said about someone was protected. Firms had not been protected. They were open to external competition, and then the tariff was protecting them. And the question is, or the risk is, how the protected firms behave. So the best of all monopoly profits is a quiet life. And the risk is that the firms with a quiet life aren't so great. And so you mentioned innovation, but maybe there'll be no innovation, and that the drivers for innovation were coming from external actors, or the risk of external actors. Christina also mentioned a teenager in her basement. I don't have a teenager, and he's not in the basement, but I've got 3 large trees at the bottom of my garden, bordering my neighbour's garden. My son is 10, and one of the things he needs to do to earn some money is to rake the leaves. He rakes the leaves on my side, and he rakes the leaves on my neighbour's side. And my neighbour loves him. He turns up, he rakes the leaves, he bags the leaves, he gets his money. On my side, he does not do a good job. Tools are everywhere. But on my side, he's protected because his mum just gives him the money regardless of the job. But for the neighbour, he has to do a good job. So on my side, he's having the quiet life. Cartoons, tools everywhere. I basically rake those leaves. Right? On the neighbour's side, and she always say, oh, send your son round, he does such a good job with the leaves. Right? So when you're facing competition, you need to do a good job. And it's very difficult to predict these outcomes. How will people behave when they don't have the incentive, when they're just going to get their money regardless of how much effort they put in? And so there could be the standard collusion, there could be some abuses, but the other consequences are really much more difficult to predict. How do firms, when they are protected, when they're entitled to an income, regardless of how hard they're working, how much innovating, how do they behave? And it's a risk. It could all go well. Leaves could be raked, but my experience is leaves don't get raked.
Yeah, I think one real life example of that is the car company Renault in the 70s, where heavily subsidized, and it was just not a good performing car. Like, it was just not a good car, and it just kept on. Like, French government, as I understand it, continued to subsidize the car company through several like near bankruptcies, and but yet the French were still driving and touting the Renault.
So I do have a teenager in the basement who refuses to get a job. I came here thinking we were going to talk about tariffs and antitrust, but apparently we're criticizing my parenting skills.
This is a therapy session.
I guess.
Yeah.
So the way I thought about this question, just as a practitioner who advises clients who are in desperate need of advice in these uncertain times, I thought of this in three different verticals. So first, from a merger controls perspective, if I have a client who is considering a merger that is likely to or somewhat likely to get investigated, then we are going to take this tariff policy that's crazy and chaotic right now and think about whether or not there are arguments we can make about incentivizing entry, and whether or not there are arguments that our competitors or potential competitors can make to say that they're going to be barred from entry because the domestic market has these tariffs on it. So there are additional considerations from a merger perspective that we think about, and we think about the company's risk in terms of antitrust and mergers, and the consequence of those risks are that we might put antitrust risk shifting provisions in their contracts to shift those risks away from them in a merger.
Can I add on to the merger point?
Yes, of course.
I also think, with respect to AI and policy wanting U.S. to be dominant in AI, thinking about mergers, and when you're putting forward a merger that might have AI implications or semiconductors, really kind of emphasizing the overall kind of enforcement landscape and priorities. Like, hey, we have to do this merger. Like, you want to win? Like, let's do this.
This is how we win.
Yeah,
this is the innovation is going to get funded, and then we get to win.
Yeah.
So yes. We've already talked about cartels, so I'm not going to talk about that one. But then on the litigation front, if you have a client, if you are a company that is in a market that the tariffs are removing notable competition, then all of a sudden you are now in a market that is very concentrated where you weren't before. And that might mean that you have market power or that you have a monopoly power. And we've seen this a little bit in the semiconductor industry where we've excluded the Chinese competitors from market definitions because geographically they are not in the same market because we do not do business with China, right? And so then you've got a few powerful semiconductor companies who all of a sudden don't have powerful competitors. And those clients have risk that they're going to face litigation from competitors or from customers or from suppliers that their behavior is now exclusionary conduct or is now predatory pricing. And it's something that they wouldn't really have if we weren't in a place where the tariffs are shrinking our geographic market. So that's the other risk that I think about.
I'll add on to something that comes up frequently, where you're a company, you're in these uncertain times, and it's like, well, if I'm a company, how am I going to react, and how am I going to stay competitive, and what are my competitors doing to stay competitive? I think it fuels like a natural desire to want to share information because you want to collect market information to make sure that you continue to stay competitive. And this can come up in a lot of different environments. I think John mentioned trade associations. And associations like that can provide a lot of pro-competitive benefits, but as we antitrust litigators know, trade associations and other benchmarking activities can prompt antitrust scrutiny, especially when the companies are exchanging confidential, competitively sensitive information, which includes confidential price information, cost information, strategic plans. And this has been even before the tariff policies kind of came to light, this area focusing on information sharing and anti-competitive impacts it might have has been a priority of the antitrust enforcers and private litigators. And so that is an area that I'm sure Robin also frequently counsels on.
Yeah.
what can we share while we want to get more information? We have talked about, single firm behavior. It's okay, it's permissible for companies to raise their prices. They're going to have to if they're facing increased input costs. And generally, the federal antitrust laws don't prohibit what we call price gouging, like increasing your prices. But if a firm is raising prices, beyond what, there's a lot of state laws that cover price gouging, and I'm not overly familiar with them, but there can be limits to what you can, or how much you can increase your prices to.
Yeah, ignore the states at your peril. They are paying attention right now.
Thanks. The practical perspective is interesting and helpful. I'm sure you're busy right now. I want to take a look back at history for a sec, and we had a nice framework from Ambassador Tai this morning, a big picture overview of sort of economic era transitions. But historically, have we observed shifts in trade regimes correlate with shifts in antitrust policy? We talked about in the first panel, maybe we're in a new policy regime or trying to build a new policy regime for trade. Is the same true of antitrust? And what lessons might history offer for us in this moment in time? We'll kick that one to you first, okay?
So, if I think about the change in regime, a good way to look at it is when trade barriers are removed. So, if you think about that, ignore for a moment the market participants, but how does the regulatory environment change? It's been alluded to by Robin and others that how, as a technical matter, you begin to define markets and think about who are market participants, who are your competitors, that changes. So you have a market that's been noted, you've got a conception about how you're defining markets, and if you begin to erect trade barriers to exclude firms from the market, there'll be changes when you move away from a globalized system of trading to a more parochial system, to have pariah states or other states, but large states with whom you're not allowed to trade, who you're excluding from the market. So there'll be changes as a technical matter in market definition. When you begin to do this, that you can also think about your thresholds and your numbers. All the numbers and the thresholds that you've defined, like where your turnover is, how you're calculating the turnover, does all of that still make sense if you're excluding so many firms from the marketplace? A number of certainly EU instruments were based upon market share. Exemptions if you had a market share below a number. Liability if you have a market share above a number. How do you recalculate all of those things now that the landscape has changed? Again, an example of environmental sustainability. One of the issues that was arising there was, where did the benefits occur and where did the harm occur? And big debates about whether or not you could take into account benefits outside of the marketplace. So the price is going up within my territory, but there's an environmental benefit in somebody else's territory. Do we still need to care about that now that it's outside of the purview of our market? So if you were just looking at America first, the idea that the fossil fuels were being burnt somewhere else is no concern. And the idea that this agreement might be a good agreement if it was preventing fossil fuels being burnt somewhere else, how you would begin to look at that would also change.
Anyone else want to weigh in on historical changes, what lessons we learned from those?
So when thinking about this question, I look back at prior episodes of antitrust sort of changes and trade changes, and I don't think I could do a better job than what the ambassador did with her arc. But if you do look at the rates of tariffs specifically, rather than sort of these broad policy characterizations, which are important for the global sort of macro approach. But if you dig down, there's not really, I didn't see in what I was looking at, the correlation between calibrating more or less antitrust enforcement and tariff rates per se. I don't think there's a clean correlation. I mean, there's episodes we could point to. 1990s, what was it? It was NAFTA, and there was a sort of a trade liberalization. I do think that was an era of antitrust where there was a greater injection of antitrust, economics into antitrust, and maybe a perception that we should do it more evidence-based and a market-based approach to antitrust. I think that's a pretty good episode, but I don't think that makes the correlation. Maybe today with our America First approach to tariffs, obviously, and the uncertainty as to where antitrust is headed today, it's another question. Although there, I would also caution, while I'm the first to say, yeah, who knows what's happening today? Actually, I say it all the time, and I agree with that. But what about the data? What's actually happening with merger enforcement? What's happening with unilateral enforcement? How many enforcement actions are actually being taken and enforced? We hear the high-profile cases, but I seem to recall someone did that during the last sort of leadership at the agency, and it was largely consistent-ish with some change in aggression in lack of settlement, and so there are clear differences, not washing that over. But in terms of the bigger picture, if someone was independent, didn't know what was this debate, just looked at the data, they're like, yeah, it looks business as usual, if you will. And I'm curious to see what this administration will do in terms of its data when we look at it. And so that's kind of the caution I would have, the caveat I have. I think it's very easy, and including myself, to say there's these large antitrust changes, and it's not clear to me that it's actually true, other than certainly on the margins in terms of willingness to settle, sort of the speeches from the agency heads. All those are different and important, and they guide policy, but I'm not so sure there's a strong correlation. It's kind of my conclusion based off what I've seen, but maybe others have a different view.
Interesting. Megan, Robin, do you want to weigh in?
So the U.S.'s interest in kind of being a global participant in trade policy and competition policy is a little scattered. So in the 50s, I think it was, there was a Havana charter that was sort of out of the pre-WTO facility. It contained anti-monopoly language. It contained competition rules that everybody was going to agree to, but the U.S. wouldn't agree to it. They felt that the rules were too loosey-goosey and not straightforward enough, and so, we could not come to the global table at that point. And then GATT came out of that. And again, GATT had some anti-monopoly competition type language in it. And again, our Congress wouldn't ratify that language, saying it was not consistent with the U.S.'s policy. So we've talked a bit about silos today in terms of trade and competition. I think there's also a silo from a historical perspective, even when we aren't siloing within our country of trade and tariffs, that we can't seem to agree with the global momentum on something, and I think that has been a bit of a lever that has caused us some issues that we need to kind of decide and get over in order to kind of have a true global economy, which may not be the goal. Sorry.
So a lot of my practice focuses on representing companies in conduct investigations, whether it be criminals, price fixing, bid rigging, market allocation, or other conduct that's not pursued criminally in the United States. And so when I think about, just kind of putting the trade piece aside for just a moment, like what kind of events historically have prompted potentially criminal antitrust conduct or cartels to flourish? And the idea that external events have created these uncertain environments, and it's just kind of what I was saying earlier, it's natural for companies to react in a certain way that may be anti-competitive. And so the idea of there being like crisis cartels, that's long been around, a phrase that we've heard within the antitrust bar. When COVID happened, there was a big rush of antitrust enforcer statements saying, don't engage in, just because we have this crisis doesn't mean you can fix prices or engage in other anti-competitive conduct. And so this is just one example of there being kind of an external event happening that creates uncertainty in markets. Just recently, we saw this with eggs. There was a huge increase in egg prices. You couldn't even buy eggs in some stores in DC, which I still just I cannot fathom in my mind. And a lot of egg producers were pointing to, well, there's this avian flu outbreak, like we have to kill all these birds or whatever they're doing, and it's causing a massive spike in egg prices. And but I'm not involved, so I can say publicly there's been discussion that there is now an antitrust investigation into egg producers and saying there might have been an avian flu, but that did not. You were also maybe talking to your competitors or signaling to your competitors that you were going to raise prices a lot. So and I understand that's ongoing. And I would expect it to for some time. So just while it's not specifically related to trade, these kind of uncertain environments, kind of shocks to the markets can create just opportunities for anti-competitive conduct to happen.
Thanks. Switching gears, over the last several years, we've seen a good amount of bipartisan consensus. On the prior panel, I can't remember who, but someone talked about you've got the neoliberals in both parties, and then you have sort of the populists and progressives that have come together on antitrust issues, as well as some global consensus and cooperation around antitrust enforcement, particularly of multinational technology companies. What effect do you see the current U.S. trade policy having on that bipartisan consensus, as well as on global cooperation? We've heard Christina say that antitrust is dead in Europe, so that's not a great sign for global consensus or cooperation. And we've heard some about risks for antitrust on American companies, which are the large multinational technology companies. So,
You still do kind of little business.
I'm glad the industry as a whole isn't dead. We've also heard about risks to incumbents, particularly vertically integrated incumbents, which include these multinational technology firms. What do you perceive as far as enforcement against these technology companies and the differences the tariffs may have on different companies depending on what they produce and how they're integrated?
That's a big question, Brooke.
That's a huge question, and I just added like 4 to the pre-prepared questions. Wherever you'd like to start there, Megan.
Yeah, I think just stepping back for a moment, it is an interesting observation that there has been the appearance of bipartisan consensus as it relates to antitrust enforcement in big tech. I think that it's important to remember that they're framing the issues in a different way. For example, the Biden administration was very focused on market structure. What market share, as Oke said, what's the market share of all the firms in that specific market as we define it? Kind of moving toward a more aggressive focus on structural framework of markets. And the concept of big is actually bad. We used to say big is okay so long as you weren't abusing your market power, but there was, I think, kind of a more aggressive shift to use novel theories to just go after big firms. On the more conservative side, we have still seen a focus on using antitrust enforcement as a tool to go after big tech companies, but I think it's been more rooted in just a focus on content moderation and making sure that big tech companies who do play a role in information proliferation throughout the U.S. aren't having, an unwieldy role in determining who gets heard and when and where. But both functionally, I think, do translate to more aggressive, continued aggressive Section 2 enforcement of big tech. And I think we would anticipate that. I think I mentioned at the outset, this America First antitrust policy will continue to see a focus on labor enforcement. There was a case I was involved in Las Vegas last spring that involved a home health care provider that had agreed with other home health care providers to fix the wages of nurses. And that was prosecuted by DOJ, Antitrust Division, criminally, and the owner of the company was indicted and then actually found guilty by a jury in March. And AAG Gail Slater touted that as a big win for both nurses who are labor in more classic labor is U.S. As we define it, and in an important industry like healthcare. So yes, labor will continue to be a focus, and then as I mentioned, like the pocketbook issues, healthcare, food. I just saw something was announced today with the Department of Agriculture, kind of focusing on agriculture. That we expect to continue to be a focus.
I do find it fascinating from the first panel, especially Christine. Was it Europe in the base? Europe's the teenager in the basement.
It actually isn't my expression. It's orange cast.
Okay, someone's in the basement, but it's Europe. Teenager.
My kid.
And this feels actually like early 2000 GE Honeywell, where the Europeans blocked that merger and the US DOJ approved it with some consent. And I remember being at the agency, and this created a great deal of controversy, sensing these are US champions, what is Europe doing? I don't know how it ultimately played out. I mean, they were blocked.
I can tell you how it played out because I was in the case, and Bill Classic was sent with a memo to Mario Monti and telling this is how we enforce in America, you do this,
Wow,
right?
I didn't know Bill was involved.
This is the
Yeah.
truth, and that's why Europe turned neoliberal, and ever since then, we basically applied the Kovacic doctrine.
Yeah, no, and so I can
It's
see.
not a touchy subject.
Well, I can see how that applies to big tech. I mean, Europe obviously has every right to enforce the laws in their jurisdiction, and the U.S. companies dominate a certain space. It's not, I don't think, targeting per se, but one can see the U.S. perspective in the sense that these are U.S. companies. Imagine if these were EU companies and the U.S. disproportionately in an industry targeted. Fair or not, these are all perceptions rather than perhaps reality. And so that seems to be a guiding force today, and I find that context incredibly important as we go forward, because there's a tension because the U.S. is also investigating these companies for the same things, and so it raises questions as to why. And I mean, we can get into that discussion as to why. I think we all probably have our reasons and to reconcile this tension. But holding that aside, I do think that context is incredibly important as we move forward in terms of how we assess what this new administration is going to do in terms of antitrust. And looking at the trade deficits, as Tim said, is this really America first in the sense that we've been in a deficit since 1970, so it's a good 50-year run that the U.S. has been in a deficit. So those who want to fight back have at least some bullet points to share. We're up to $1 trillion in the trade deficit. But is that really harmful to Americans per se? Because the goal isn't necessarily an equal trade, but certainly the welfare of companies and consumers and workers. And so I think, that being said, that nuance is lost when we talk about trade policy. We're looking at the deficit, we're looking for at how long, and it just gives sufficient ammunition for these questions. And I think that's where it's hard to get past these points and say, hey, can we look at the merits of the case? And that's really very uninteresting to a lot of people these days.
So let me add some things.
I have a lot to say, but I will keep going.
So, Anu Bradford writes about the Brussels effect. This is the capacity. She does. That's it. I've not said anything controversial yet. Give me a chance. So she writes about the Brussels effect. It's the capacity of the EU to impose its standards. And she celebrates it in
Everyone laughs. Only her and the Commission celebrate it. Come on,
in
the
a.
dumbest thing ever.
But she does write about it.
We're gonna let
She
OK finish.
does celebrate it. And she celebrates it in this particular way. So there's the capacity of the EU. And essentially it's an ability to impose its standard as a condition of firms accessing its market. And what has happened is the table has turned because the EU regulatory standard has been treated as a barrier to trade. Okay, so what happens in the administration is to look at imposing EU tech regulation, EU taxation, is seen as a barrier to trade, triggering a retaliatory trade type measures. So the initial approach is to say you cannot access the EU market unless you comply with that standard. And the turn is to say, well, maybe you can't access our market, and who's got the bigger market? And this is then the idea that Europe was then weak because the size of its market and what was in its market was, if you had to choose, was not the most attractive of the two. So there's first that change in the Brussels effect and how big, strong, powerful, real the Brussels effect was to begin with. A second point that we've been speaking about enforcement, but all enforcement being discussed appeared to be public enforcement. What is the capacity of an agency? What's the agency going to do? But the traditional idea was that most enforcement was private enforcement. Most enforcement was through the courts, you say through the state attorneys general, and that this wasn't enforcement that you were counting out, and what hasn't really been the enforcement that people have been talking about. And so how that is impacted, I don't know. Maybe that enforcement is never against big tech, which shapes and dominates the debates that we have. When there was private enforcement in big tech, it was big tech being sued by slightly smaller big tech. And that this enforcement wasn't really about the consumer. This is more about rent sharing. This is all terrible, and how much of this should I have? And so they were reallocating the spoils rather than changing the dynamic. And so there was a particular type of private enforcement which was not to a beneficiary. This then comes back to the remarks of the ambassador into why did this consensus break down? And it's clear that the consensus has actually broken down. And it hasn't just broken down within the US, it's actually, I think that's a broader phenomena that consensus has broken down. In that when we were speaking about consumer welfare and efficiency, that appeared to be the corporate interest. And there's an idea that the corporate interest, or the particular corporations of interest, need not necessarily be certain. So who was the beneficiaries of these particular policies? So there's sometimes a shift in the literature, not to speak about consumers anymore, but to speak about citizens, in which the idea of America first, it's not just like America first, it's more Americans first. And so when you thought about labour markets, it wasn't just like workers, it was like American workers, domestic workers might be considered or preference within this new realm. The phenomena also not so new and not shocking. I think yesterday Christina said the UK committed suicide. Brexit. And so the UK also had some, I don't know, falling out crisis when it left the European Union. And it also has a revived or renewed approach to competition policy, where in no way manifested in anything that might seem coherent or implementable, constantly talks about growth, that the strategy, the approach is all about growth. So there's a new growth agenda. Is there the former head of Amazon is the chair of the authority, driving it towards its newly targeted growth agenda. So you could think about citizens, we could think about America or Americans first, we can think about growth, but somehow consensus has broken down. Who is enforcing the rules and for whose benefit is also up and open for debate.
Do you want to add anything, Robin?
No.
John, we talked about, with respect to this question, the difference between the types of products or services that these firms make or add. Do you want to tease out that distinction a little bit and how the tariffs might affect what we perceive to be similarly situated large firms differently?
Yeah, I mean, we talk about big tech, but at least for some component of their services, these are not going to be impacted by tariffs. They're not importing anything in terms of goods and services. A lot of them are platforms with services and users and advertising, and at least my understanding is those are subject to tariffs, and so it's going to have sort of effects on some markets and no effects on other markets. And this discussion actually raises this question of what the nature of market power is. And Oke mentioned that monopoly power is a quiet life, and I agree with that. I think that's true. And so if we don't see a quiet life, doesn't mean we don't have a monopoly. And so someone raised the Amazon settlement in the prior, and what I think we should be cautious of is not market power as the boogeyman per se, but what is it that market power is doing licitly and illicitly. So for example, the Amazon case, the settlement, my understanding is that's a consumer protection case on dark patterns of how to cancel Prime. We all have experiences, market power, big or small, of difficulties with canceling gym memberships and various other things are notorious for that. This is independent of market power in terms of these types of inquiries. And so I know it's Amazon and it's exciting to say it's market power, but I would push back and say it's not a case about market power. It's a case about consumer protection, whether we agree with the decision or not. That's the focus of it. And sort of another example is privacy. Many point to privacy, and I think it's rightly an issue. In Europe, privacy, GDPR, it's beyond regulation. It's a fundamental view of sort of a human rights to your information, and I think that's not as appreciated in the U.S. So that's a defense on the European side of their values, which may not be our values, but I don't think that implementation is necessarily targeting big tech per se, and I think that's a bit unfair. But to apply it to market power, what is privacy in market power? Well, many have posited that market power gives you the ability to degrade and harm people's privacy, and it may, but what I did a study with James Cooper, and we tried to empirically examine whether market power was correlated with privacy harms and quality, and we couldn't find any. And I would encourage anyone to go to the FTC site on privacy regulations and fines. And what you'll see is big companies, small companies, guys in basements, violating privacy left and right. And so I just think it's a more complicated question on dimensions that we tend to assign to market power, especially in tech markets. And this isn't to say we don't want to solve the problem. I just think that if we're going to diagnose the problem, pointing to market power, I think we're going to miss the mark. And I agree, these privacy harms are problematic, but I think we go in the wrong direction if we're always pointing to what we think market power is doing and not doing. And so again, this is not a defense of unlimited market power. It certainly isn't, but rather assigning market power what we should assign it to.
Thanks, John. All right, before we turn the time over to questions, I'm going to try to pull together some thoughts and throw you one last kind of big picture question. So 2 things we've heard about from various panelists and Ambassador Tai, that we have policies, and then we have what Ambassador Tai called tools, what Oke called rules. We have antitrust policy, we have trade policy, and then we have antitrust tools and trade tools. And then we have the recipients of those. We've talked about this on this panel. I think sort of the 3 main groups we've talked about are workers, consumers, and companies. My question is, to what extent should the policies of antitrust and trade coincide to reflect a value judgment in the same way? And to what extent should they reflect different value judgments about what tools to use, who the recipients of those tools should be? Should they reflect a coherent policy of, say, America first, or we are trying to benefit everyone in our economy, or to what extent should they kind of stay in their lanes, and antitrust is really focused on competition and we're going to do our best to promote competition. Trade is really focused on our relationship with other nations. That's what we're going to focus on. This is a philosophical question. I didn't give it to you beforehand, but I think it's a nice rounding between the last 2 panels. Whoever wants to jump in first.
Okay. So
Thanks, Robin.
since I skipped the last one, I guess I'll talk this time. Earlier today, we had a question about the Whirlpool Maytag merger and how anti-dumping regulations were not part of the ultimate decision that the DOJ made not to block that transaction. And I do think that that was a turning point at the division and a lesson learned. And so for the most part, trade policy is now at least under some consideration at the DOJ, particularly when a merger or conduct case involves manufacturing that is happening outside of the U.S. So steel, aluminum, those cases, every party that's involved will come in and say, oh, we have so much competition from outside of the U.S., and that is investigated. I think that that is a policy that should be built upon and continue. I think there is probably no harm in some coordination between the trade group and the antitrust group. And Biden made some noise about this in his executive order when he took office that said all of the agencies should be coordinating on competition issues. I don't believe that trade was part of that march at that time, although I think I had already left the division, so I'm not sure on that. But issues, we should be approaching competition with a whole of government approach. We should be approaching trade with a whole of government approach. And if we're not, we should teach and educate those of us who have practiced in the government to understand the issues. I mean, everybody that I worked with at the DOJ was incredibly intelligent. I'm sure they are capable of doing that. So I would advocate for a policy of a whole of government approach. Then I think at the pulling lever, tools level, that approach, it can be very divergent. Antitrust cases are very fact-dependent. Investigations are very fact-dependent. I assume decision-making at the trade organizations are very different investigations, very different thoughts. I don't think that the tool level needs to be as aligned. So staff, for example, doesn't need to understand what trade tools are being used at the division or at the FTC, although I would recommend that people at the decision-making level, such as the front office, certainly have an understanding of what the trade policies are and how that might implicate competition issues.
Thanks, Robin. Yeah.
So, at this point, they're asking a question, like, how do you know that life is getting better? Like across these things. So, particularly, like how you report it is that GDP is up. And I say GDP is up, like there's been growth, and that means life is getting better, apparently. It doesn't quite mean life is getting better, but it's supposed to be the proxy that life is getting better, right? So you have some growth, say like stock market's up, GDP up, life's getting better. Stock market down, GDP down, life is getting worse, okay? So life is getting better when GDP is up. And then the breakdown in consensus is that people are telling me that life is getting better because GDP is up, but doesn't feel any better. Maybe it feels worse. And so I think one question is like, how can you come up with a better way of describing how life is? And the loops back to a conversation I was having at lunch, like what is the function of wealth? So we had the original robber barons who appeared to give it away. Although they were sort of villains, but they endowed philanthropic institutions and public institutions, and they did something with their wealth. And the question is that also true today? And so, is life getting better? What is the function of wealth, and what are you supposed to do with it? And I think this comes a lot into when trade is happening and an economy is growing. What does that actually mean?
We like to talk about antitrust, and maybe trade is the same. Like there are immutable economic characteristics that we can apply and can show us the answer. But it is pretty impossible to answer this policy question without value judgments. Whose welfare are you going to maximize? Who does the wealth accrue to? And then at the tool level, how do you make that happen? I think that's a really good point. Megan or John, do you want to weigh in?
Just in terms of the observation of how to administer these two policies, and I'll go back to where I started just to reiterate and my belief on this. I view trade more as policy. I know it implements itself in terms of laws, hopefully at some point, and I get that. And antitrust I can perceive as more laws, which obviously also has policy. So I'm not naive to say that they're completely divorced from each other, but I do think antitrust is more of a body of law, I think as it should be. And trade policy is more policy, and policy changes with administrations, and it has different objectives. And we've sort of listed those objectives. But I think antitrust is something that its value, if it has any, is in its predictability. And if we don't have predictability in law, what do we have? We have uncertainty. We might as well not have it, is my view on antitrust. So as a body of law, to the extent it is, and I think it is, I believe that predictability is sort of the key. And predictability of what? Of course, that's the value judgment, and what is it that we're being predictable on? I mentioned the consumer welfare standards, what we currently have. There are alternatives. But that being said, I do think that that's a pretty guiding thing. So where am I going with this? I think that if we consider antitrust as a larger part of administrative policy, we weaken the value of antitrust. And maybe that's what people want, but I think that's the positive effect of antitrust. And I would prefer, I think normatively, that we have a trade policy, which is fine, and I probably should be more predictable in various things. But I think antitrust should, to the extent possible, remain sort of a consistent body and applicability.
Yeah, I was actually going to say a similar thing. Like antitrust in the U.S. is the federal antitrust laws are antitrust laws, and while at the federal level, different administrations may view how to approach enforcement of those laws differently. They're ultimately bound by the precedent that has been established over past 100+ years in the courts. There are also different enforcers of the antitrust laws. Most of our discussion today has focused on federal antitrust enforcement. But we cannot forget that there are also state AGs that have their own state laws that generally are consistent with federal antitrust laws, but they also approach their enforcement actions with their own kind of values-based judgment. We saw a lot of Republican state AGs going after sustainability initiatives in the past 4 years because they view that, they're trying to approach those issues as antitrust violations. I think that's where the using antitrust as a tool comes up. But then there's also private plaintiffs, consumers who are also bringing antitrust actions as another way of enforcing the antitrust laws, and do so through federal laws and state laws.
So, don't we agree that trade policy has implications for competition policy and vice versa? Then why wouldn't we encourage the agencies, the U.S. competition agencies, to understand the trade policy? I'm not advocating that they follow the trade policy as much as they understand the implications of that trade policy.
That's my position too, definitely.
Oh, okay,
Yeah,
okay.
100%.
Yeah, I think at that level, there's consensus.
Okay.
That at least, we've teased it out in this panel, that in different ways the trade policy can affect competition. As Oke mentioned at the beginning, removing barriers may encourage companies to impose their own private barriers,
Yeah.
but heightening barriers may encourage other activities that violate antitrust laws. So I think there's no way around the fact that they are linked, but really interesting discussion what that means at a policy level and an implementation level, and I appreciate all of your perspectives and candor. We have about 5 minutes if there's any questions.
I have a lot of comments. Can I take 2 minutes?
I'm timing you, Christina.
Okay. So I heard about 80% of things I vehemently disagree with and 20% of things I agree with.
Well, tell us about
I agree
those.
with the position that the whole of government approach perhaps best captures the notion that we ought to be cognizant and recognize disciplines. I am very much on the same page, and this is the campaign I've been doing in Europe forever. Just open your mind, right? Trade, competition, not science. So with that, I agree entirely. In some dimension, the panel was a bit meandering, so I'll pick up a few of the things I disagreed with, which isn't to say more than I have a different perspective. But ultimately, what I keep banging my head against is the view that, competition law is competition law because there is a dominance of lawyers and you want predictability. Jolly good, I'm an economist, I'm not in that camp. I don't care about precedent. As an economist, precedent means zilch to me because to make analogies to other markets, other times, other periods of history, zero interest. For me, the question is this particular conduct in this particular market at this particular time. That's the only thing I care about. And in that sense, things change, they evolve. There isn't a single law or rather a single interpretation that we need to establish once and for all. Things need to evolve. So no, I'm saying this because there is this kind of notion that we need predictability and we need to establish things in a way that is immutable, and it is part of the resistance to change. There is enormous resistance to change in antitrust, which comes from the position that, forgive me, the lawyers take, that things need to be certain and we need to explain it to clients and everybody.
20 seconds.
Time. I'll take another one.
Wait, let's let John respond to that one. Do you want to respond?
Well, just real quick, I'll let you keep going, Christina. I'm very interested, and I appreciate your comments and thoughts on this. I'm not trying to reconcile this. I don't think we're that different. When I say predictability in law, I don't mean a statutory sort of write out, like an AI printout of what you can and can't do. I don't think that serves us well. It's the notion that there's a certain set of tools that we apply to market analysis in order to assess the objectives that we currently have. That leads to certain precedents, but those precedents, as we all know, is like a common law where it kind of evolves based off of economic learning and various things. I don't want to overstate the value of economics in certain areas as well. We do need some degree of guardrails for what firms can and can't do. But I generally, from what you're saying, I agree with that's how we assess markets. So to the extent that that's true, and maybe I mischaracterized what I'm thinking, but that's consistent with how I think we should do antitrust.
I won't reply because, of course.
Pick up another thread, yeah.
A couple of other things that I have to say. I think we need to be clear that there is a US antitrust and a European antitrust. So much of the discussion, insofar as it applies to US antitrust, is very different from Europe. I'm sorry, the Brussels effect has always been a joke, will ever be a joke. No one in the world seriously took, apart from European officials, the notion that there was this stupid Brussels effect, because nobody really adopted what Brussels did, nobody really took it on board. This is a fantasy of the Europeans. On this, I will not ever move. But in the US, the discussion now on enforcing against digital companies is very much what we are dealing with in Europe. And as you say, this is something I agree with. There is something of attention. What are we to do in Europe? When we have the very same companies, it's a problem. We have the very same companies that are behaving sometimes in egregious manners. Now, we ought to be doing something about it, but Europe's enforcement is true, has been very weak. Because fundamentally, for reasons of, we cannot really enforce hard against American companies, we'll always do something behavioral and pathetic. So that is the reality. So, and there is a question of sovereignty. What can we actually do as Europeans when it comes to this? And that is the kind of thing we're wrestling with.
Thanks, Christina. We're at time, but I'm going to let Tim ask one question, if that's okay, Craig. All right.
Thanks. I was curious about your, at least, perception of the development in the last few months in U.S. antitrust. What we're seeing in trade policy, I think we've had lots of discussion on that in this morning, is that all kinds of issues get raised as at least getting added to the objectives of trade policy. Some of that might be rhetoric, some of that might not be news, but things that traditionally might have been industrial policy, that may have been social policy, it seems to be demanded, at least rhetorically, that trade policy address and to some extent solve all of those things. Are you seeing any similar changes in U.S. antitrust at the DOJ and or the FTC?
So I think we are seeing some social causes, some pressure to have some social addressing in environmental and sustainability goals and freedom of speech goals. So we are seeing a little bit of an expansion of antitrust, but I don't think I can think of something that's changed, like an industrial organization point of view, or I don't know, John as an economist.
I think that's fair.
Yeah, Megan is a practitioner.
Yeah, just the point that maybe we were making about mergers, like the using the trade policy as like
as defenses, or so there is that. Yeah, that's fair. So that's another way in which we've seen some expansion is trade policies, is defenses for a merger, and then also as arguments against a merger. So that plays both sides of the cards. Yeah.
I think from academics, there are a lot of values that have been thrown in as potential things for antitrust to maximize, everything from income inequality to privacy to, so I mean, I
privacy,
think,
that's another good one.
And labor, which has always been covered by the antitrust laws, but not historically been enforced, and that's active and alive. So I think there.
Yeah.
That's changing in the last 8 months.
Oh no, I would say in the last administration.
Yeah.
And the last 8 months.
Yeah, in the last 8 months, we've seen the freedom of speech and the idea that environmental and sustainability goals are collusion. That those are the two, I would say, top considerations that are fairly new.
Just one small point, particularly like in framing it as antitrust as something else, it raises the scope of treble damages, and that is a big driver in like how you might settle and how you might frame certainly what in the EU, if you're able, it changes the complaints mechanism and the mechanism of enforcement. That if you can call it an antitrust complaint or a competition complaint, it's easier. Like the way that you get funding, the courts that you can go to is different. So the receptiveness to those sorts of argument, I think, has changed over time, and it's really, so whilst you might think about it as substance, it's really about using the enforcement mechanisms of antitrust, because it has, although it's dead, more efficient enforcement mechanisms than lots of other areas of law.
All right, thank you so much to our panelists.